Welcome. Welcome to A Taste of Justice. I am Professor Angela May Kupenda, and this series is for all of us. It's for my current students to help them take a soak in the law and not a quick shower. And it's for all of us who believe in the pursuit for justice in our country. So today I'm here to tell you about some of the student position statements that the students wrote and have presented in my First Amendment class this semester. If you want to know more about the statements, take a listen to video 22 or video 23, and it will tell you all about this exciting time we're having in my First Amendment class. It has several goals. One goal is to help the students in reviewing and in applying the principles we have learned to current First Amendment conflicts that we are facing in 2021 in this country. So go back and look at those. I'm going to resist going through telling you all about the project and the various goals that I have for my students. Now, I do want to say that my students prepared a written 3-page statement that they submitted to me, and I've read them several times. In addition, students presented. They had 5 minutes to present their position in class and to encourage students to join their position and to deal with that disagreement that some had where they did not agree with the position the students were arguing from their classmates. Now, I want to point out, though, that here, these interpretations of the cases are my own, and I'm giving you summaries of my students' statements to protect their privacy. I am not giving their names. So therefore, these summaries are my own, and I hope that they clearly represent what my students argue in class. For informational purposes only, I'm telling you that I'm a professor at Mississippi College School of Law, and I've been teaching in law schools and business schools for almost 30 years now. So let's get right to these statements. Now, in the text box below the screen, I've listed the titles of all of their position statements so you can read them and you can keep a record as to whether you agree or whether you disagree with my students. And in addition, I've given the short names of the cases that they relied on in shaping their positions. We have 44 students in the class, and this is the second group. Every week I'll come and I'll summarize for you the statements that the students submitted and presented. Now, for most of the statements that we're going to talk about in this video, most of them relate to student speech and or online speech. So before I start, I want to briefly review for you. I want to briefly review one case and tell you about another case that is coming up, and that will help you in following their statements. Now, most of these for today are about student speech. In a case called Tinker that we've talked about before, Tinker involved a case from the 60s. Some students came to school wearing Black armbands in protest of the Vietnam War and also in protest of racial inequality. They had a silent protests. The school disciplined them for that protest and for refusing to remove the armbands. The US Supreme Court ruled in favor of the students. And the court said a couple of things. The court said, first of all, that teachers and students do not leave all of their First Amendment rights outside the schoolhouse gates. In other words, when you walk into the school, you carry some of your First Amendment rights with you. For teachers, it's called academic freedom. Then the second thing the court said was, although students do have some First Amendment rights, when they enter into the school, they do not have the same rights that an adult has who is outside the school. The court said, of course, they do not have the same rights because the goal of being in the school is learning and education. So they do not carry the same rights in as adults have who are outside the school grounds. Then thirdly, the court said that the student's speech and Tinker was protected because it did not materially or substantially interfere with the educational purposes of the school. So that sort of became the Tinker test. Over time, though, things have become, in some ways, a bit more complicated. You know, the next question was, well, what about student speech that occurs outside the school? Can schools still punish that speech? And there have been a number of cases, but none that have so far made it to the US Supreme Court. Well, kind of, sort of. The Morse case we talked about before, the students were arguably on a field trip and they were disciplined for holding up that banner. Remember, the one that said "Bong hits for Jesus." You can go back and watch the clip I did earlier on student speech. So now we have settings that may be more complicated in some ways. What about student online speech? Can a school punish a student for what the student says online or on social media if they make the statement while they are away from the schoolhouse setting? And that's the issue we're going to look at shortly. There is a case, and I've given the name of the case in the text box below. You'll want to follow that case. The Supreme Court is scheduled to have oral arguments in that case in late April of 2021. But the case is titled BL versus Mahoney. I may be pronouncing it wrong, but I've typed it in, school district. So what happened there? So there was a ninth grader who was a cheerleader, and she wanted to move up to varsity cheerleading. She tried out and she didn't make the team. She would have had to continue with the cheerleading, ninth grade or freshman group that she was in. She was quite upset, quite disappointed. She went online, I think something called Snapchat, and to some of her friends, the filings in court said 250 people, including some of the girls who made cheerleader. She said some things about the school, and she used the F word, the F-bomb. You know what I'm talking about. She used it a number of times, saying F the cheerleading, F the school, what have you. Some of the cheerleaders who saw the posting, they went to the school. They did not want her to be allowed to cheer with them. They were upset about the things she had said, and the school disciplined the young lady, BL. The school disciplined her and said she would have to sit out of cheerleading for a year, and she has brought suit. So it raises this issue about speech that occurs outside the school, speech that occurs on social media outside the school. Can the school punish her for that speech? And I think it also raises another issue. She was not suspended from school. She was suspended from an extracurricular activity in the sports program, cheerleading. So can the school then have different social media policies for students who are participating in certain activities than they have for others? I think that's another issue that is raised here, but we will see when the court hears the case. Now, let's go to the students' position statements and see what they had to say about student speech online. The first student, her argument, her position is this, and you can read it in the text box, but I'll read it to you now. The First Amendment does not grant school officials the authority to regulate off-campus student speech under Tinker, unless said speech is closely related to a school organization. Now, in her position statement, she talks about Tinker, and she also gives us the background on the case that we just talked about. And she said, of course, there are positions that are different from hers. She does not believe that in this case that we talked about, in the case involving BL, she does not believe that that speech, the comments that student made, were closely related to a school organization. Therefore, she argues, my student argues, the school could not discipline her for that speech. She said, of course, there are positions that are different from hers. We think about the Tinker standard. The Tinker standard says that student speech can be disciplined if it materially or substantially interferes with the school process. But she says she disagrees with that position because then the school would have too much authority over students. She believes the school should have that authority over students' online speech away from the school only if it's closely related to a student organization. Otherwise, she said, the school is really substituting itself in the place of the parents. She argues that since BL made these comments when she was away from the school on social media, it would be the place of the parents to discipline her for that, and that the school did not have authority to remove her from cheerleading for a year. What do you think? Do you agree with my student on this issue, or do you disagree? Make a note, make a mark, and we're going to go on to the next one. Okay, the next student says the Tinker rule should not apply to off-campus speech by students. And so here the student is referring to the same case. She is essentially agreeing with the first student, but she made some different arguments that I want to summarize here. She argues in her position that because the speech in Tinker happened on campus, but this speech did not happen on campus. So she says, and I'm going to read it, she says the speech could not have materially and substantially interfered with the schoolwork or discipline of the school because the speech did not happen on campus, and that it is not the school's job to discipline students for things that happened off campus. She makes a very interesting argument that social media is like a Walmart parking lot. She said that back in the day, young people may hang out in a parking lot and they may say all kinds of things. But now, instead of hanging out in that way, they are hanging out on social media. So she believes that this off-campus speech should be off limits from the school being able to discipline the student. Wait, she had something else I wanted to mention. She says that because it was off campus, it could not substantially interfere with education. But I'm wondering what the court is going to say about that point, because the petitions filed to the Supreme Court indicate that there were other students who actually pressed the school to discipline the student. They did not want to cheer with the student because of the things that had been said. But my student here argues that off campus should be the line, and that Tinker should not apply to any speech that is spoken off campus, even if it is then discussed on campus. Do you agree with her, or do you disagree? Make a note as to what you think. Let me go to the third statement. Social media policies at public schools do not infringe on the First Amendment rights of their students. So this student, he appears to be expressing a different or somewhat different position from the first two students. He takes a look at a specific policy, although he does reference Tinker and the case that we talked about that the court has granted cert in and will be hearing soon. He took a look at a social media policy at a public school district here in Mississippi. And that school policy said that students could be disciplined for speech on social media, even if they spoke those comments when they were away from the school. But that school's social media policy dealt specifically with two types of speech. It addressed cyberbullying and sexting, I guess texting with sexual images or depictions. And so his position is this. I don't think he all the way agrees with what the first two students said. I think he steps back a little bit. He says that public schools can have social media policies that violate or that address speech by students off campus. He said that while students do not lose all of their First Amendment rights, you have to take in consideration the educational mission. So here he says that, and let me go back a step. He said that some social media policies of schools ought to be upheld. And here he believes that the social media policy of this school district that relates to cyberbullying and sexting, that policy ought to be upheld as constitutional, even though it infringes on speech, because it is not overbroad. Okay, but let me read. I missed something. He says also he agrees with the earlier statements, and he does not believe that the speech by the cheerleader should be regulated by the school either. But he does believe where there is cyberbullying, bullying, or sexting, the school can regulate that speech. I'm glad I cleared that up. He's probably saying, get my statement right, Professor Kupenda, and I think I did. He wants to carve out certain areas where the schools can regulate speech that occurs on social media, but in the other areas, he does not believe schools should be able to discipline students for their speech online. Now, we have another position statement, also on student speech. And she argues off-campus speech that promotes violence, bullying, and harassment of others should not be protected and be free from punishment by public school officials. So she also talks about Tinker, and she talks about the case involving BL that we're going to hear from the court about. And she says, I understand that students do want First Amendment protections, but her position is that off-campus speech should be protected, but then she adds to some extent, sort of similar to the statement I just told you about. She says students have speech rights, but these policies are valid to some extent. And she says if a student posts something that is offensive about a fellow student or bullies a fellow student online, where the post could lead to a fight when they return back to school, she does believe that the school can restrict that speech. She says her position is that a student's off-campus speech should be protected, but not to the full extent. She talks some in her statement about the difficulty there would be for schools in terms of shaping appropriate regulations for any of this speech. She said, what is on campus and what is off campus anymore? During the time of, as we're dealing with COVID-19, many schools went online for their educational processes. So she says the line between what is on campus and what is off campus has been blurred. She thinks that one approach is to put this speech in the middle. Remember, we talked about the middle category, which gives more deference to government, but also some protection to speech. It's not all the way making the speech unprotected. It fits somewhere in the middle categories. And that is what she argues here, that maybe something like the O'Brien test, where the court is, the school is concerned with not silencing the speech, but the secondary effects of the speech, maybe that is an approach that could work. Okay, so we'll hear the court's oral argument in late April. You can Google the case. I have the name, and I'm sure it's going to be interesting. You can think back on what my students have argued and whether you agree or disagree with them. Okay, let's go to the next one. He argues that free speech zones must balance speech rights with public safety. Now, he says this is an ongoing issue, and particularly he discusses speech on college and university campuses. And he argues that on some campuses, they have set up free speech zones, and that's where you go to protest or what have you. But in his view, some of these zones are so limited. They are either small areas or you can book the area for only a limited period of time. He argues that, of course, the university must balance speech with safety, but his position is that perhaps some of the schools have gone too far, according to his position. He says that what if a person wants to protest on campus and they want to march around? He argues that maybe our schools could carve out zones to allow a marching protest, right? To make sure that in the protest, they're not coming closely to a high traffic area, perhaps, or an area where classes are in setting. So he believes in the educational mission of colleges, but he also believes that should be balanced with allowing speech zones on campus. And he argues that some of the restrictive zones are too restrictive of speech. What do you think? Do you think there should be free speech zones on campuses? Do you think that if we're balancing the two, where do you balance? Are you more in favor of restricting the campus in accordance with peace and safety and the educational mission and all of that? Are you more in favor of the campus allowing for free speech and protest zones and those matters as a part of the educational mission? When you balance the two, where do you give greater weight? That is really the question that he is posing in his position statement. Okay, but I found his suggestion about the marching protest zone areas to be fascinating. Do you agree with him or do you disagree? Let me go on to the next one. Okay, so the next statement reads, cancel culture and freedom of speech do not clash in the workplace, because freedom of speech does not mean one is protected from consequences of those actions. Now, this was another very interesting position statement. You know, you hear a lot in the news about cancel culture, and some people in favor and some people in disagreement. And so in her position statement, she says that speech rights are not absolute, and that speech rights have never been absolute. And so therefore, if you speak, you may have to bear the consequences of your speech. And a consequence of your speech may be that you're canceled. Here she's looking at that a consequence of speech may be that your employer, the company you work for, may decide to terminate your employment. Now, she makes some very interesting arguments that under Citizens United, corporations also have a right of speech. So she says that a company ought to have the right to terminate an individual because of their speech and because the company may not want to be associated with the ideas that I expressed. Now, her paper argues in her position that she is in favor of free speech rights. She says that she is in favor of the marketplace of ideas concept. However, she says that individuals may still be held or should still be held accountable for their speech. You know, we had an interesting conversation, a discussion in class about the marketplace of ideas. And that now with speech rights, and as the country is becoming more diverse, some viewpoints have been spoken freely over time. But now those viewpoints, if a person express those viewpoints, they may find that they've lost maybe they lose a book deal, maybe they lose their job, maybe they're disciplined. So does this mean that the First Amendment is not working, or does it mean that the First Amendment is working as the marketplace is going through these shifts? And I think that's part of the question that she's arguing in her statement, that while a person may have First Amendment rights, those rights may also come with consequences, and that a corporation also has speech rights and associational rights, and they may decide to terminate a person because of their speech. Do you agree with her statement, or do you disagree? Make a note. Okay, let me tell you about the last statement. The last statement is this: social media speech should be analogous to special industries like common carriers or the broadcast media. Therefore, allowing the platforms to be subject to content neutral regulations by establishing the government has a substantial governmental interest that is narrowly tailored in order to defeat a First Amendment challenge to an individual's fundamental right to free speech. Now, this is also a very interesting statement. Now, do you remember we talked about a case called FCC versus Pacifica? It was a case where a man was driving with his son in the vehicle. They were listening to a radio station, and all of a sudden, a monologue came on the radio station using the F word and all types of words that many people may regard as indecent. And so the question was, given that the speech was spoken on the radio through the broadcast media, where people couldn't get away until it was already heard to some extent, can that speech be regulated more? And the court suggested it could, because it was on a radio station during the daylight hours, not in the evening or late hours. So she argues the same. She argues that social media platforms can be regulated by comparing them to the broadcast media. And therefore, instead of completely silencing speech, you use some type of test that is more so in the middle. You use a test in the middle, similar to, we talked about this a little bit earlier, related to the O'Brien test. Now, she says that, of course, some people would disagree with her. They would say that these social media platforms should be wide open, anything said, pursuant to the marketplace of ideas theory from Justice Holmes' dissenting opinion in the Abrams case. But she says that even though these are good arguments in protection of speech, she does not see, she believes that the government can regulate. How can the government regulate the speech that it needs to without carving out some type of mid-level test? She says that this mid-level is critical to deal with situations such as speech on social media, perhaps as related to the January 6th incidents at the Capitol. So here she's arguing for a middle test, not wide open speech to say whatever, not a total suppression of speech, but to use a middle level approach so that government can take in consideration the overall welfare of our country by restricting speech that may incite violence. So what do you think? Do you agree with her that there should be some middle approach where social media is concerned? Or do you believe that it should be all wide open, regardless of consequences? Or do you believe government should have great control to regulate? Or do you agree with her with some type of mid-level, mid-degree, where you're balancing the interests of speech against the governmental interests in not promoting the incitement of violence? Wow. And we're just getting started. I'm going to be back next week and tell you about some more of my students' position statements. Look, as I said before, I had certain goals for them, and I told them they all did amazing jobs. For me to say they did amazing as their professor is not to say that I agree with all of their statements, but I agree that they articulated their statements and supported their positions very well while dealing with and considering the disagreement to their position. Look, learning is the pathway to enlightenment. And in learning, we have to consider what we believe, but we also have to consider the opposite positions and think on these and evaluate them. Learning is the pathway to enlightenment, and enlightenment can lead us toward freedom. Freedom can lead us toward justice, or at least a taste of justice. Subscribe, sign up for notifications. You don't want to miss a thing. I'll be back next week with more of my students' position statements. Bye-bye. You take care.